that Fran and Edward were living with the Josephs if it weren't for one person, Lauren Miller?
Well, I really can't say that. I can't say that we would never have known if it weren't for Lauren Miller.
Who brought up the question of Fran and Edward living with the Josephs?
Lauren Miller did bring it up, but it's not that we...
Your Honor, we would ask that counsel allow the witness to please finish her answer.
Would you like me to repeat
Yes, would you
that
please?
question? Isn't it true that you would have never acted against the Josephs if it weren't for one person, Lauren Miller?
Yes, Lauren Miller did bring it to our attention at that time, but we cannot say that, we would have never found out.
With the indulgence of the court, Your Honor?
Your Honor, that was the wrong question. She already answered that one. It's the question directly after that one that we'd like.
Your Honor, it was the same question, but phrased in a different manner.
But it's still the question we were asking for.
Has the witness answered your question?
Yes, she has, Your Honor. No further questions, Your Honor.
Your Honor, at this time we would like to call Ms. Janet Hook to the stand.
Raise your right hand, please. State your name.
Janet Hook.
For the purposes of this proceeding, you may consider yourself sworn. That means you're sworn to tell the truth in the proceeding.
Please state your names and current address for the court.
Janet Hook. I reside at 220 Lincoln Drive in Philadelphia.
What is your educational background, Ms. Hook?
I earned my bachelor's degree in economics from Penn State University, and I earned my master's degree in business administration from the Temple School of Business.
Have you ever authored any articles in your field or done any studies?
I've authored numerous articles on management strategies for homeowners associations. In addition, I've done over 24 studies in the fields of adults-only complexes.
What is your current employment status?
I'm owner and chief executive officer of Hook Realtors.
What is your area of expertise, Ms. Hook?
I consider myself an expert in the field of management strategies for homeowners associations.
Your Honor, at this time, the counsel would like to submit Mr. qualifications as an expert in the field of housing sales and management strategies.
We'd like to cross-examine the witness, Your Honor, on her qualifications. Ms. Hook, how long have you been a realtor?
Your Honor, we request a bench conference this time, please.
No, Your Honor.
Your Honor, at this time, I would like to submit Ms. Hope's qualifications as an expert in the field of housing sales and management strategies.
Yeah, do we have any objection to that in the interest of moving a trial?
No objection, Your Honor.
We will accept it as an expert in the field.
Thank you. Ms. Hope, were you hired by Society Hill Towers?
Yes, I was.
And what kind of work have you done for them since being hired?
I oversee their annual budget plans, and I also participate in the sale of some of their condominiums.
Do you receive a fee from Society Hill Towers, Ms. Hope?
Yes, I do.
Are you receiving monetary compensation for your participation in this trial claim?
No, I'm not.
Ms. Hope, when did you become interested in adult-only complexes?
While I was working on my master's degree.
In your expert opinion, what are the advantages of these adult-only communities?
Adults-only communities provide a place where older adults and professional adults may reside without having their freedom curtailed by the presence of children.
Your Honor, at this time I ask that this exhibit be marked offenses to the name. Ms. Hope, could you identify this exhibit for us, please?
This is Society Hill Towers operating expenses for the years 1975 and 1984.
Ms. Hope, who prepared this document?
I did.
Do some of the management expenses decrease when complexes are adults only?
Yes, they did.
And as an expert, do you have an opinion as to why these decreases occur?
This is because Society Hill Towers is an adults-only community.
In relationship to this graph, Ms. Hook, do the 1975 and 1984 percentages add up to 100% of the total budget operating costs?
Yes, they do.
As an expert in the adults-only field, what are the advantages of the reallocation of the budget expenses between the years 1975 and 1984?
As one can see from looking at this graph, Society Hill Towers homeowners are now receiving more for their money. They've gained a greater recreational and administrative staff. In addition, they've gained greater recreational facilities, including 2 Olympic-sized pools, a sauna, and a fitness center. Also, while maintaining all of these facilities, they have still been able to cut their repairs expenses in half. And also, their insurance has been cut by 15% since 1975.
Your Honor, at this time I ask that Defense Exhibit 1 be offered into evidence.
Any objections to the admission of the exhibit, Counsel?
Objections, Your Honor.
At this time I ask that this document be marked Defense Exhibit 2. Ms. Hook, could you... I'm sorry. Could you identify this exhibit, Ms. Hook?
This is Society Hill Towers property projections for the years 1975 to 1985.
Ms. Hook, who prepared this document?
I did.
When did you prepare it?
1976.
And what is the purpose of this document?
To provide Society Hill Towers projected property values.
Could you explain to the court, Ms. Hook, what is a projection?
A projection is an estimation of what property will be worth in the future.
Did you obtain the actual value, not a projected value, but an actual value of a Society Hill Tower one-bedroom apartment in 1975?
Yes, I did.
And what was the market value of a one-bedroom apartment in 1975?
$30,000.
When did you last sell units in Society Hill Towers, Ms. Hook?
1984.
And how many units did you sell in 1984?
12.
Could you please tell us what the average sale price of these units were in 1984?
Over $75,000.
And how does this compare with your projections for 1985?
This price is above and beyond my projection.
Based on these statistics, what conclusions do you come to about adult-only complexes?
That adults-only complexes definitely cause property values to increase.
Your Honor, I ask that Defense Exhibit 2 be offered into evidence.
Do you have any objections to the admission of the exhibit?
No, Your Honor.
Would you like a copy?
Ms. Hook, what research have you done lately into the availability of single-bedroom apartments?
Over the past 2 weeks, I've checked the classified section in the newspaper, and I found over 175 single one-bedroom apartments.
Did the Pescos or the Josephs ever contact your agency searching for an apartment?
No, they did not.
But is your service provided, Ms. Hook, free of charge to all residents of Society Hill Towers?
Yes, they are.
In your expert opinion, are there apartments suitable for families such as the Pescos?
Yes, they are.
And recently, has your agency received any inquiries from landlords desiring to rent their apartments?
Yes, it has.
Would you, as a professional, be willing to aid the Pescos in finding a place to reside?
Certainly.
And could you possibly provide a list of these available apartments that you spoke of earlier to the Pescos or the Josephs?
Yes.
Thank you, Your Honor. I have no further questions.
Ms. Hook, since when have you been a realtor?
Since I earned my master's degree in business
And what
administration,
year was that?
I believe 19. I'm not sure the year, I'm sorry. 19.
You're not sure when you earned your master's degree?
No, I'm not.
Have you published any of the articles you've authored?
Yes, I've authored numerous articles on management strategies for homeowners associations.
And you published all of them?
Many of them have been published.
In the course of attaining your MBA, did you take any classes in the field of management strategies for homeowners associations?
I took many fields in economics, leading to my earning my knowledge in strategies for homeowners associations.
But did you take any actual classes in management strategies for homeowners associations?
No, I did not.
Isn't it true you received a $7,500 income from Society Hill Towers?
I received a retainer from Society Hill Towers of $7,500.
Isn't it true you also earned commission from sales of units at Society Hill Towers?
Yes, just as any other realtor would.
Isn't it also true that your primary occupation is a realtor?
Yes, I'm owner of my realtor firm.
Isn't it true that a person with no money, no income, no job, no financial resources, and burdened with a child has little or no chance of obtaining an apartment on their own?
I would not say that. There has to be some way for the Pescos to attain some sort of living arrangements, either through my agency or through the help of Ms. Pesco's family.
And being a realtor, what sort of ways would you suggest to Ms. Pesco?
Well, she could come to me for some lists of available apartments. All you can do is check with each apartment and each landlord.
But how will she pay her apartment if she has no job and no income?
Your Honor, this is beyond the scope of Ms. Hook's qualifications as an expert. She has no knowledge of Ms. Pesco's finances.
Your Honor, this is very relevant because she works for Society Hill Towers.
Well, the objection is that it's beyond the scope of her testimony as an expert witness.
But it was established earlier that the defense would use Ms. Hook to help find the Pescos a place to live.
Yes, but counsel is asking Ms. Hook, our expert witness in economics, whether or not Ms. Pesco can afford this apartment, and Ms. Hook has no knowledge of Ms. Pesco's finances.
She stated earlier that she had classes in economics.
She still would not understand the individual finance.
Thank you, Your Honor. Did you hear the testimony of Professor Kennedy?
Yes, I did.
How do you know Professor Kennedy?
I had him once as a teacher, or professor, I'm sorry.
And how were you as a student?
Your Honor, this is irrelevant. Ms. Hook is testifying as an expert witness in the housing strategies of homeowners, and this has nothing to do with that at all, Your Honor.
Goes towards the credentials of...
Your Honor, that's already been established in the bench conference.
Thank you. Did you hear Professor Kennedy testify that 76% of all housing has some sort of anti-child restriction,
Yes, I did.
but you still feel that you can find Ms. Pesco an apartment?
Yes, there are some out there for Ms. Pesco.
Isn't it true you prepared a graph in 1977 on Society Hill Tower's projected property values?
Yes, I did.
Do you have that graph?
No, I don't.
Your Honor, excuse me, but my graph has some writing on it. Would that, do you have a plain one? Thank you. Oh, not that one, the projected. Thank you. So, can you please read the date on this document?
1976 is when it was prepared.
But you just stated that you prepared the projected property value graph in 1977.
No, I prepared it in 1976.
My previous question was, isn't it true you prepared a graph in 1977 on Society Hill Tower's projected property values?
Your Honor, objection. If that was the question, then counsel was misleading the witness, and it was an
This
understandable
was
possible
prepared in
mistake.
1976.
Your Honor, if I may bring up the witness's affidavit where she stated she did prepare it in 1977. Thank you. Ms. Hook, isn't it true the document only shows projected values and not actual values?
There is an actual value listed. That is the 1975 price of $30,000. That was an actual value. The other two are projections. The
Projections.
1980 and 1985 are projections.
This date is now 1986. Can you give us actual values for 1985 and 1980?
Not at the present time. I couldn't have them with me.
So you've not prepared an updated document on Society Hill Tower's property values?
No, I have not,
Your
but I
Honor,
have sold.
This document was prepared in 1975, and therefore she would not have any knowledge of actual values in 1986.
As an expert, Your Honor, we feel that she should have an updated document. Can you please repeat that?
I have stated that this document was prepared in 1975. You are asking Ms. Hook for an actual value in 1986. It is an impossibility to have an actual value in 1975 for an apartment.
Let the witness say that, and you should have to take time. I know what
Thank you, Your Honor. Isn't it true you stated earlier in your affidavit that maintenance, insurance, and the like invariably decrease?
Yes, that is true.
Can you please read the percentages spent on
Your Honor, I
maintenance in
object.
1975?
Counsel did not go through official procedures for this court and procedures.
I'm sorry, can I show the witness the documents?
She must refer to the exhibit as...
What exhibit are you showing?
It's the defense exhibit. Number 1, Your Honor, the 5 graphs.
Showing the witness.
Defense exhibit number 1. Can you please read the percentages spent on maintenance in 1975
23%,
and in 1984?
26%. But this is due to the fact that Society Hill Towers has gained more facilities. Therefore, they will need more money to deal with in their maintenance expenses. They will need the money, and they had to reallocate that. That was necessary in order for them to maintain the atmosphere for the adults-only complex.
But that was not correct earlier.
Pardon me?
But that was not correct earlier. It is now, after they reallocated.
Well, that was necessary in order for them to maintain their new facilities.
Isn't it true the money spent on recreational staff increased by 8%?
Yes, it is.
Isn't it also true administration has increased by 15%?
Yes, it is. That again is due to the fact that they have undergone a conversion and that they have gained greater facilities and they need qualified people to staff these facilities.
Thank you. These are all percentages I see here. Can you give an actual dollar value where maintenance, administration, and recreational staff has increased?
I do not have actual dollar values for them. These are percentages.
No further questions, Your Honor.
Your Honor, the defendant would wish to rest our case now.
Excuse me?
We would like to rest our case now.
No, but before the plaintiff rests, we would like to move that plaintiff exhibit 1 be moved into the record as evidence.
Excuse me, Your Honor, what was...
Your Honor, the plaintiff's exhibit number 1 was already offered into evidence. Defense.
We offered it as identification, Your Honor. Yes, sir.
Oh, I'm sorry.
Any objection?
No objection, Your
It
Honor.
is so admitted. Testimony is now admitted, and we are ready to proceed. That's contrary to the litigation. You there dispense the video. Are you ready?
Yes, Your Honor. Your Honor, may it please the court?
No person under the age of 21 years shall be permitted to reside in Society Hill Tower. By now, ladies and gentlemen, you recognize this as the adults-only phrase found in every deed at Society Hill Tower. The defendant, Society Hill Towers Homeowners Association, asserts the validity of the adults-only provision and the deed as non-discriminatory. The only issue before the court is whether Society Hill's proposed action against the plaintiff, Annette Joseph, constitutes arbitrary discrimination. Naturally, it is the defense's position that this is not arbitrary discrimination. We shall prove this through a three-pronged test, as illustrated in Farnback v. Henderson, 1976. First of all, the proposed action is reasonably related to the protection of the health, safety, economic, or general welfare. Through the testimony of Ms. Falk, who has sold actual units at Society Hills, unlike Dr. Kennedy, we have learned that since the conversion to adults only at Society Hill Towers, number one, there's been an increase in the sales price and an increase also of the value of the unit. Number two, there exists a decrease in management costs. Number three, there also exists a decrease in operating and repair costs. And number four, a remarkable decrease in insurance payments. Now, it is evident that there are economic advantages. While there are some increases, this is understandable when you take into account inflation and cost of living increases. The continuation of the adults-only provision at Society Hill Towers is related to the continuance of such economic advantages. Concerning economics, it's also important to note this time that Dr. Kennedy is personally involved in this case. He knew the Pescos, he assured the Pescos' mother that he would do everything he can for them. While Ms. Falk gets paid, whether or not we win this case or lose this case, she's on a retainer. Her testimony was not personally involved. Ms. Price, the president, testified that the Society Hill Towers simply does not have the facilities to accommodate children. The recreational facilities there are for the benefit of the adults. The unfenced Olympic pool, the fitness center. To reconvert these facilities to accommodate children would be an economic burden. We take into account the general welfare. What if Edward wandered away from his grandmother? After all, children are curious. And what if he wandered into the unsupervised fitness center and was seriously injured? Or what if Edward wandered into the Olympic pool and drowned? Who would be responsible? Well, according to Hall v. Weisberg Development Incorporated in 1963, the Homeowners Association, here's the ironic part, including the Josephs themselves, will be responsible and will be economically liable. The Homeowners Association cannot afford to have children playing around the adult recreational equipment. This is related to protecting the economic and general welfare, and therefore passes the first prong. Secondly, the proposed action does not cause unreasonable hardship for the Josephs. Mrs. Joseph signed her deed and by doing so agreed to the adults-only provision and to enforce it. Now, the Josephs were correctly advised by D&G's attorneys that the restriction did not bar the continuing residence of Frances. Yet Frances moved out. She surrendered her right to residency, and therefore the provision no longer applies to her. By signing their deed and by Frances moving out, the Josephs have created a hardship for themselves. They broke the rules, and ignorance is not an excuse, ladies and gentlemen. Society Hill Towers Homeowners Association, however, is acting with compassion. It was the Homeowners Association that waited 10 months before they took any action. 10 months. This was in light of the tragedy that befell the Josephs. The Homeowners Association felt that 10 months would be a reasonable amount of time for the Josephs to find adequate housing for Frances and Edward. Once action was taken, Josephs were given an additional 90 days to find housing. So over a year was given to the Josephs to find housing. His defense's contention that is indeed a reasonable amount of time to find housing in Philadelphia, whereas Ms. Hook testifies in 1 week she reported 175 single-bedroom apartments in the Philadelphia area. Now, if the Josephs really wanted to find housing for their daughter and their grandson, they would have done it by now. They're creating their own hardship. Therefore, passes the second prong. And thirdly, the proposed action does not cause unreasonable harm to the public interest. Freedom of choice. Freedom of choice, ladies and gentlemen, is this valued privilege that the defense wishes to preserve in this case. The majority of the residents of Society Hill Towers are there because they have exercised that freedom of choice. And in doing so, have chosen to live in a child-free environment. They paid for their condominium, they should get the expected environment. We cannot now allow children to move in, for it violates this resident's freedom of choice to choose the environment they live in. The Homeowners Association upholds that freedom of choice is an important value in our society. As part of the plan today, we strike down that very basic freedom that all Americans wish to enjoy, and therefore passes the third prong. Now, keeping all this in mind, the proposed action does not constitute arbitrary discrimination, and does not violate Section 1604 of the Philadelphia Civil Rights Code. Before closing, I'd like to examine the plaintiff's case for a moment. They made quite a fuss about how there were 4 absentees, yet it has been shown that was a legal form, that the vote was taken, that it holds, it's binding. 40% of representatives were there. A total of 16 representatives were there, and still majority vote. The form is legal and it's binding. They demonstrated, they tried to prove the cost went up. We've already demonstrated the testimony of Ms. Cook, the costs have gone down, insurance payments have gone down. In fact, it's more beneficial to be a resident living in Society Hill Towers now, economically. They say that Society Hill's created a hardship for their daughter and grandson, but we've already shown that the hardship was created by themselves. And they claim it's a harm to the public interest because it takes away the Joseph's freedom of choice. But unfortunately, they're asking us to take away the freedom of choice of the other 456 residents of that community. We submit that the majority here is their freedom of choice should be taken into account also. Today, the defendant is asking the court to do 3 things. Number 1, to declare the adults in the provision valid and in full force and effect. Number 2, to reaffirm the power and authority of the Homeowners Association to enforce the adults-only provision against the plaintiff who is in violation thereof. And number 3, to grant defendant's counterclaim for possession of Unit 3 at Building 4519. Thank you, and we are confident you will render a just verdict.
Your Honor, the plaintiff would like to present this trial memorandum to the jury before we begin our closing. In it are repeated various laws which are referred to specifically in our closing. Would you like to see it? I'm sorry, Your Honor, I would like to present you with this trial memorandum since you are rendering the decision in this case. Plaintiff apologizes for any inconveniences may have caused the defendant.
Thank you.
Your Honor, ladies and gentlemen of the jury, distinguished opposing counsel, you've heard this evening the case of Mrs. Annette Joseph, the plaintiff, against Society Hill Towers Homeowners Association. Mrs. Joseph argues that the adult-only restriction presently in effect in Society Hill Towers is a form of arbitrary discrimination. Such discrimination is in direct violation of Pennsylvania law, specifically the Philadelphia Civil Rights Code. Mrs. Joseph requests, therefore, that the restriction be declared null and void. She further enjoins the court to prevent Society Hill Towers Homeowners Association from enforcing the restriction against plaintiff's family. Through first-hand and expert testimony, plaintiff has proven that defendant is arbitrarily discriminating against plaintiffs. In the case of Hornbach v. Henderson, 1976, a three-pronged test of arbitrary discrimination was established. The adult-only restrictions imposed at Society Hill Towers failed each and every prong of this test. The first prong of this test states that arbitrary discrimination is unrelated to protecting health, safety, economic, or general welfare. You've heard the testimony of Mrs. Annette Joseph. She testified to the fact that the crime rate has remained unchanged. The safety of the Society Hill Towers community has not been protected by the adult-only restriction. You've also heard the testimony of expert witness Darlene Kennedy. Dr. Kennedy has shown conclusively, based upon her own studies, that the adult-only restriction has had devastating effects upon the economic welfare of Society Hill Towers residents. Cost of living have increased 300% as a direct result of the conversion to adult-only. Plaintiff acknowledges the fact that you have heard the testimony of Janet Hook to the contrary. We would like to point out, however, that Ms. Hook has a good relationship with the defendant. A relationship in which the defendant pays Ms. Hook $7,500 a year for her services. May we submit to you that Ms. Hook would be perhaps more than happy to testify for the defense in the hope of maintaining the sizable income. Also this evening, Ms. Hook contradicted two statements she made in her affidavit. As a result, plaintiff tends to somewhat disbelieve the credibility of this witness. The second part of this test states that arbitrary discrimination is a cause of unreasonable hardship to those discriminated against. Figures presented in an official study by Dr. Kennedy have shown that plaintiff's daughter would be homeless should she or son be evicted. The sadness of such an event should evoke the sympathy of any rational, kind-hearted human being. However, Mrs. Joseph has already appealed to the sympathy of Society Hill Towers Homeowners Association. Obviously, the management has no sympathy. They've done nothing to assist the Josephs in finding a home for Mrs. Pesco and her son. Mrs. Joseph has been living at Society Hill Towers for the past 24 years, peacefully with her family. All she asks is that she be permitted to continue to do so. Mrs. Joseph was led by Society Hill Towers into signing away her rights. She was told that the restriction would not apply to her. Now, the adult-only restriction threatens to break up her innocent family. Is there any hardship more cruel and unreasonable than this? The final clause states that arbitrary discrimination is unreasonably harmful to the public interest. It has been brought out in testimony that Mrs. Joseph's daughter and grandson were residing with her for 10 months prior to the receipt of the eviction notice. During the duration of the same 10-month period, at least 3 building representative meetings and 9 association officer meetings were held, in which the question of eviction of the Josephs was not even discussed. Plaintiff wonders why, if the presence of a child is such a burden to the community, why the management took 10 months to do anything about it. Only one of the many residents of that community complained. Also, it is always in the public interest to promote and observe just laws. The adult-only restriction is not just. It is also in the public interest to promote the happiness and welfare of its citizens. The adult-only restriction does not. In summary, the adult-only restriction is arbitrary, unreasonable, and harmful to the public interest. In any case, plaintiff would like to stress that fact that Society of Hill Towers Homeowners Association cannot legally enforce the restriction under the given circumstances. According to law, Society of Hill Towers may not take action against any specific homeowner unless confirmed by majority vote from its representatives. Only 9 of the 20 representatives voted in favor of the eviction of the Josephs. Clearly, this does not constitute the required elected vote majority. In closing, I thank you, Your Honor, and members of the jury, for your understanding and kind patience in considering this case. Claims is very strongly about the case, and we feel that we have presented the facts to you quite clearly. We are hopeful that you will render a decision in the client's favor. Thank you.
All rise. Court is now in recess.
Court, ruling on the merits of the legal issues involved, and finding in behalf of the defendant on the basis that the plaintiff has not established arbitrary discrimination in this case. It's not to say that the situation is not unfortunate, which has befallen the Josephs. However, there are some remedies available, and the court would urge that the cooperative attitude expressed by the defendant by offering assistance to Mrs. Joseph and her son find housing be followed up at no cost to Mrs. Joseph. The issue with proof of arbitrary discrimination obviously very difficult, but the facts of this case do not warrant such a finding so as to overturn a restricted clause which has been in effect for 480 property owners since 1977. Now, you've been at this, what, 20 weeks?
Since February.
Like one more critique, wouldn't you? And if I hear one more word about what we did or didn't do, I don't know if I can go any further. So I will make some very general remarks. It is late, and I know that you're anxious to get on to better things and learn more. Whatever I am saying, of course, understand that they are my personal remarks. Take what you want out of them. I thought all of you did an outstanding job, but you performed very well, very well. I think that the logical progression in your questioning, particularly with the witnesses, was very good. I think that you moved from one area into another very smoothly, and I know that there have been, maybe there are, a lot of county attorneys in the courtroom tonight. They would be scared to death and wondering to get their jobs in the future when they get into the area. So I congratulate all of you. You did extremely well. I think that you perhaps have in the papers perhaps a little more restricted view of what's scope beyond the scope of direct examination. You cannot limit it to just a repetition of a question you asked. If you open up an area, i.e. meetings or whatever it may be, then the other side is permitted to expand the subject. They can't go to a totally new subject. But once you've got the subject, even if you've only asked one question, once you've got the subject up, they are permitted to expand on that subject and pursue it further than you did. So I think that we want to look at your objections in that area, being beyond the scope, because you find that you did raise the issues and they were and should have been committed to expand upon. The issue you all wondered about, the issue on the majority voting for the change or voting for the sanction, you both properly raised it because it's right in the problem, and you both brought it up. I think that where you got a little hung up, particularly in the defense, you did not lay the foundation to be able to respond to what they said. You never established, you said what was the vote, and I did 7, and that's as far as you went. You didn't establish, was this a quorum? Was the quorum present? Was this a majority vote of the quorum? You see, and once you had established, if you had established that, they certainly could have questioned and say, well, it wasn't a majority of the whole. But you then could argue to the jury what you did. If you argued to the jury something that you had not established, you argued that it was a majority of the quorum, and the word quorum was never read by you. So I don't think you have to anticipate that they were going to raise this issue, but do anticipate it in the next round so that you can establish what you want to as to what it is. Take judicial notice that you're going to call it Pennsylvania law, the situation is, as you indicate, there is a quorum and a majority of the quorum is a vote. But that we both raised the issue very properly, and we almost got tied up in knots on that. It is important when you are introducing exhibits that you have the exhibit mark, that you show it to opposing counsel and you show it to the court. Because the court sits here. I happen to have the copy, so I know what you're talking about. But in an ordinary case, the court doesn't have it. So if you don't show it to the court, and you start asking the witnesses, the court has actually nothing to talk about. So don't, it's almost three things: get it marked, then the counsel, and then the court. I bet you did magnificently well, all of you, in avoiding all the hearsay. Because I'm sure you've gone through those, and I think you certainly have no problem with that. Perhaps the most difficult area in any trial, you may do it or not, are the opening functions, because the opening, you tell the jury what it is you're going to tell them, and you get your witnesses on, you tell them, and then you close up and say, this is what I told you I was going to tell you. You're repeating it, and you're repeating it to the term. You want to make sure, and at the beginning of your business, you want to make sure that you don't in your opening tell everything that your witnesses are going to say. Because then when the witnesses get on the stand, the jury says, oh, I know you're going to say it, so you know what you're going to say. You don't want to tease the jury. This witness is going to talk about what's going to happen to this child. If you say this witness is going to come on the stand, he's going to tell you this child is going to be thrown out on the street, and he had no food, he had no money, or that, then maybe they're going to listen when your witness is on, because you already told them. If you kind of want to give them, kind of want to tease them by giving them gentle background of what it is that you're going to present in your case and what you expect your witnesses to say. And have them then expand upon that, and then it makes the trial that much more interesting. Some of these things can get awfully dull, so you have to do. I find as a general rule that when you're talking to the jury, that it is better to be as close to the jury as you possibly can, because I think that's how you develop the rapport with the 12 people that you're going to be talking to. I think one of the most difficult things, and the one thing that you will find, let's say that way. One of the things you want to avoid doing is reading. Reading opening, reading closing, reading all of your questions. Because it doesn't seem like this is a natural flow of events, that it's all too terribly rehearsed. When you read an opening, when you read a closing, all of us, we talk too fast. We want to get done, we want to get finished. And all those marvelous dramatic points that were made in the closings could very well be lost because you were in such a hurry to get finished, you reading too fast, you forgot the dramatic parts. A lot of this is acting too. A lot of this is presenting. You're presenting an argument, and you're presenting your point of view, and you're trying to talk 12 people who believe in your point of view. So sound good when you're at your desk and sitting there writing it, but if you read it, you lose it, so very much. So with that, generally, again, congratulate you. I wish you the best of everything. I wish you continued success. I hope that you will all pursue the profession of the law, because I think you're all tremendously good to do so. And it has been a pleasure to be with you. So
Thank you, Your Honor.
Based on the three score sheets, the scoring panel, the winning team is Greater Latrobe High School. We're going to be announcing the two teams advancing to the finals at the reception. And thank you all very much for coming. We'll adjourn for
I also, before we leave, would like to thank the three scorekeepers for sitting through 2 complete rounds of trials for the past, 3.5 hours.
It's not that
I guess we're ready. That's cool.
Oyez, oyez. The Court of Common Pleas in Philadelphia County is now in session. The Honorable Sylvia Rambo presiding. You may be seated.
morning, everyone.
Good morning, Your Honor. Your Honor, my name is William Hoover. My co-counselors are Miss Robin Martin and Miss Robin Safranco. They're representing the plaintiff this house.
Your Honor, my name is Gail Evans.
Your Honor, my name is Domenica Dean.
Your Honor, my name is Kadrujan Dahl.
All persons who will be witnesses, please rise. Please state your name individually, beginning with one on left. For the purposes of this proceeding this morning, you may consider yourself sworn. You mean you're sworn to tell the truth. You may proceed.
After ready to receive the statements.
Yes, Your Honor. May it please the court. Your Honor, ladies and gentlemen of the jury, opposing counsel, my name is Robin Martin, and my colleagues are Ms. Robin Franco and Mr. William Hoover. Together we represent the plaintiff, Mrs. Annette Joseph, who was notified that she must vacate Society Hill Towers within 90 days or evict her daughter and grandson from her living place. The plaintiff will call the following witnesses to the stand. Mrs. Annette Joseph, who has lived in Society Hill Towers since 1960, and Ms. Darlene Kennedy, who is expert in the economics field and sociology field. The principal issue in this case is whether or not Society Hill Towers has the right to evict the Josephs out of their home without evicting their daughter and grandson. My client, Mrs. Joseph, has brought this case to court to show the following. Number one, to declare that the adult-only provision in the deed is violative of the Philadelphia Civil Rights Code as a form of prohibited arbitrary discrimination against children. So under the Civil Rights Code, this provision is arbitrary discrimination, for it does not pass the three-pronged test. For number one, it is not protecting the health, safety, economic, or general welfare of the society. Number two, it does cause unreasonable harm to Ms. Pesco, her grandson, and the Josephs. For Ms. Pesco has a child and is unemployed without a high school diploma. Number three, it also causes harm to the public, for it is not discriminating against all children, but only one child. We would also like to declare, number one, that the restrictive provision is null and void and not in effect. Number three, we will join against Society Hill Towers from taking any actions to enforce the adult-only provision against my client, Mrs. Joseph, and her family. Mrs. Joseph has in fact lived in Society Hill Towers since 1960, and she has also had to raise money whenever the condominiums changed in 1977. She will say that D&G developers did in fact tell her that this provision would not would not affect her family. Therefore, Edward and Miss Pesco are her family. They were also notified that they would have to vacate this whenever they are members of the family. Mrs. Jessup will also testify that her daughter Fran has no money to pay for rent for an apartment. She has no high school diploma and therefore is having trouble getting a job. She also notified us that Miss Pesco and herself have looked for many places for Miss Pesco and her son to live in. She also states that many of these places are not accepting children, and therefore they are having much trouble. By making the Josephs either give up their home or break up their family, Society Hill Towers is breaking up our traditional values as we know it today. Secondly, we will call Ms. Darlene Kennedy, who is an expert in the economics and sociology field. She's been teaching for 24 years at Penn State University, and she has held a number of executive positions with Wall Street Business Forum. She also performs consultant services for nonprofit governmental groups. Ms. Kennedy is also a primary interest and expertise in the housing market and contemporary trends in housing sales and rents. Ms. Kennedy who showed that Ms. Pesco is faced with hardship in finding herself and her son a place to live. Through her studies, it will be proven that Philadelphia does have less than 1% housing available to Ms. Pesco and her son, and that 76% of all the housing has some form of anti-child restrictions against children. Through her testimony of Ms. Kennedy, we will also show that since the adoption of the adults-only provision, expenditures for Society Hill Towers have increased and have not decreased. Therefore, the discrimination against children, no more allowed permitted, is not good for the Society Hill Towers complex. The plaintiff will prove the adults-only provision is arbitrary discrimination, and that it should be declared null and void and not inept. This is to be made to uphold the welfare of the Josephs and the community of Society Hill Towers and the surrounding area. Thank you.
Commissioner has the hearing.
Yes, Your Honor.
May it please the court, my name is Gail Evans, and my co-counsel this morning is Domenica Dean of the New Jindal. We are representing the defendant, Society Hill Towers Homeowners Association. We have two witnesses who will help to prove our case. The first is Ms. Juanita Price, who is president of Society Hill Towers Homeowners Association. The second is Ms. Janet Hook, who is owner and chief executive officer of Hook Realtors. It is our intent to prove that Annette Joseph knowingly ignored the rules of her binding deed. Society Hill Towers was constructed in 1960 and was operated as an apartment complex. In 1977, D&G developers converted the apartment complex into a condominium complex. A new restriction was adopted stating that no person under the age of 21 years shall be permitted to reside in Society Hill Towers. The deed generously provided a special exception for persons under the age of 21 years. The deed generously provided a special exception so that persons who are currently residing in Society Hill Towers and were under the age of 21 years could remain. The Joseph's daughter, Frances, was 11 years old at the time of conversion. She was permitted to remain. The Joseph family has been living in building 4519 of Society Hill Towers for 17 years when the condominium change occurred. The Josephs are a member of and are well aware of the rules and inner workings of the Society Hill Towers Homeowners Association. We believe that the evidence will show that Mrs. Joseph is aware that when one signs a deed, that one is aware of the binding nature of the document signed. In 1977, Mrs. Joseph signed her deed. We believe that the evidence will show that she knew what was and is in her deed. She thus has a responsibility to comply with her deed and to follow the
enacted against the plaintiff, who is in violation thereof. The Joseph's daughter Frances married and had a son, Edward. When Edward was 6 months old, he and his mother moved in with the Josephs. The Josephs are thus in violation of their deed by having a person under the age of 21 years residing with them. We believe that the evidence will show that the Josephs are aware of the adults-only provision and are aware that they are in violation of this provision in the deed. Only now that this rule affects them do they choose not to follow it any longer. We sympathize with the Joseph situation, but the Josephs knowingly violated a rule agreed upon by all of the members of the Society Hill Towers Homeowners Association. We ask the court to grant the defendant's counterclaim for possession of Unit 3A of Building 4519 of Society Hill Towers. We are sure that the court will find that the adults-only provision complies with the Philadelphia Civil Rights Code. The Philadelphia Civil Rights Code prohibits only that discrimination which is arbitrary. A three-pronged test has been established to determine if an action is, in fact, arbitrary discrimination. We will use this test to prove that the adults-only communities are not in any way connected with arbitrary discrimination. We ask the court to declare that the adults-only provision is valid and in full force and effect. This case is extremely important to our client. We ask you to please pay close attention to all of the witnesses whom you will hear from this morning, including those witnesses who will testify to you on behalf of the plaintiff. At the end of the case, the judge will ask you to render a decision based upon all of the evidence that you have heard. It is our belief and hope that a decision will be made in favor of the defendant, Society Hill Towers Homeowners Association. Your Honor, ladies and gentlemen of the jury, thank you.
Your Honor, the plaintiff wishes to call Annette Joseph to the stand. Could you please state your name and place of residence for the court?
Annette Joseph. I live in Unit 3A, Building 4519, Society Hill Towers.
And how long have you lived in Society Hill Towers, Mrs. Joseph?
Since 1960.
Were there any special circumstances surrounding your purchase of your condominium?
Yes, when D&G developers turned it into condominiums in 1977, my husband and I first thought we wouldn't be able to live there anymore because we didn't think we could afford the down payment. And then we realized that's where our friends were, and we've lived there our life. So we raised the money, and we've lived there since then.
Mrs. Joseph, when was your daughter Frances born?
She was born June 29, 1965.
And how long did she live with you?
Up until 1982.
And why did she move out in 1982?
She was married.
Did you receive a deed from D&G developers?
Yes.
Was there any special provision in this deed?
Just the one prohibiting children under the age of 21 from living there from January 1st, 1977 on.
Mrs. Joseph, to your knowledge, what were the reasons for D&G developers to convert to condominiums?
To decrease the crime rate, and also they felt that it would decrease costs for people that were living there and their units.
Have you personally had any experiences with crime?
Yes, I have. My car was stolen last year, and I know 4 other people's cars that were stolen. My association dues go up every year.
Let's explore the adult-only idea. How has it affected your family?
Up until now it hasn't, and it shouldn't have, because when I signed that deed, they told me that it didn't apply to my family. And my daughter and my grandson are part of my family, and I just, I can't even believe that this is happening.
When did Fran return to you at Society Hill Towers?
She came back January 5th, 1985.
Why did she come back in January?
She came back when her husband was killed in a car
Objection, Your Honor. The death of Fran's husband is totally irrelevant to this case. This case concerns only the parties of the Josephs and the Homeowners Association.
Explain why the daughter came back, however,
What were the circumstances surrounding your daughter's return?
She came back when her husband was killed by a drunk driver, and she was left all alone with her son Edward. And she had no financial support, so she came back to live with us.
You're talking of your grandson?
Yes.
How old is your grandson?
He's a year and a half right now.
How long were Francis and Edward living with you before you were contacted by the association?
It was exactly 10 months.
There was 10 months, there was no prior contact before that?
No, there was nothing at all.
Did any of your neighbors complain about Francis and Edward living with you before October 15th?
There was just one.
Objection, Your Honor. The testimony of other residents is hearsay.
Your Honor, we're trying to establish here that she did ask her neighbors about Francis and Edward living with her, which she will testify to.
Testifies whether anyone complained directly to her about the fact that they were living with her. Is that correct?
Yes, it is. Did any of the neighbors complain about Francis and Edward living with you before October 15th?
There was just one, no.
Who was the person who complained to the association about Francis and Edward residing with you?
Says who complained to her, but she knows about who complained to someone else.
By whom and how were you contacted by the association, Mrs. Joseph?
It was Lauren Miller. She brought a notice to my door.
And Lauren Miller is your building representative?
Yes, she is.
What did the notice state that she brought to you?
It said that within 90 days that I had to either kick out my daughter and her son or else move out of my home entirely.
How old is your daughter, Frances?
She's 19 now.
Does she have a high school diploma?
No, she does not.
Does she have any means of support at all?
Just my husband and I right now.
Did she receive any pension?
No, her husband had not worked at his job long enough to receive funds like that.
What about Social Security, Mrs. Joseph?
Well, Fran applied for that, and she was denied. And we even appealed it to a lawyer, but he said it would take years before anything came about.
Has she received any insurance money?
No, yeah, she has received some, but of course that went to the cost of the funeral for her husband and also moving from Dallas to Philadelphia to come live with us.
Did Edward receive any financial support?
Just from my husband and I.
Have you personally looked into any experiences or any housing for Francis and Edward?
Yes, we've looked into a lot of places. We've called places and we've visited places. And it just seems that wherever we go, there's restrictions against children, or else Fran can't even consider them now. She has no financial support, and they're too expensive for her.
Mrs. Joseph, does your deed say what would happen if Francis and Edward, or for that matter, if anyone under the age of 21 would move in with you?
No, it does not.
How long will Fran continue to reside with you?
I'm hoping that Fran will get a life of her own soon, but until then, I feel that I'm her mother and she's my daughter, and her grandson is part of my family, and I feel that it's our duty to help her out and support her until we need, I think.
Thank you, Your Honor. There are no further questions.
Mrs. Joseph, isn't it true that you were aware of the new status of Society Hill Towers as an adults-only community when it was converted into condominiums?
Yes.
And Mrs. Joseph, isn't it true that before you signed the deed, all the restrictive clauses and all the important information were present in this deed?
Yes.
Isn't it true that this provision did not apply to people like you who were already living there?
Yes, it didn't apply
When
to
the
me.
Homeowners Association contacted you in October of 1985 about your violation, you were given a full 3-month grace period before Fran and Edward had to leave, weren't you?
If you want to call it grace period.
You do care very deeply about your family, don't you?
Yes, I do.
And you do believe that the prime focus of this case is the unfortunate situation of your daughter and grandson.
The way I see it is they're trying to kick my daughter and her grandson out of my
You do
home.
believe that they are the most important aspect of this case.
They are the most important thing to me, yes.
Because of this deep-rooted concern, you're of course well acquainted with the various alternatives your family could wisely take advantage of, aren't you?
What alternatives? We've checked into places to
You're not
live.
aware that there's an absentee owner alternative where you could rent your condominium and use the rent money for a larger apartment that accepts children?
This is my home. I want my daughter with me
You're not
until she
aware of
can...
this.
This is my home. My daughter's just with me until she can get her feet back on the ground. We barely have enough money to raise the down payment. We don't want to get rid of our home. We just want to just get a home for my daughter.
Isn't it true that selling your condominium and using the proceeds to provide a spacious home for your family is entirely possible.
I guess so, yes.
Isn't it, Mrs. Joseph, isn't it a fact that, in your own words, you really want Fran and Edward to stay?
I would like them to stay, but as I said, that they deserve a life of their own, and they will have one.
Mrs. Joseph, no further questions.
Your Honor, the plaintiff wishes to call Dr. Darlene Kennedy to the stand. Could you please state your name and occupation for the court?
My name is Dr. Darlene Kennedy, and I'm a professor of economics at Penn State University.
Dr. Kennedy, where did you receive your education?
I was educated at Dickinson College, where I earned degrees in sociology and economics, and at Temple University, I earned my master's and my doctorate degree in sociology, and from the Wharton School of Business, I earned my MBA.
For the record, please identify your professional employment background.
As I have stated, I have been a professor of economics at Penn State University, and I have held this position for the past 24 years. Prior to this, I held a number of executive positions with various Wall Street firms, and in addition to my teaching duties, I also perform various consultation services to government or nonprofit organizations.
What is your area of expertise and interest?
My area of expertise is specifically the housing market, current trends in housing sales and rentals.
Have you ever published any material on discrimination?
Yes, I have. I suppose the most recent would be a book I published in 1983 entitled Age Discrimination in Housing, Subverting Our Traditional Values.
Your Honor, at this time we would like to qualify Dr. Kennedy as an expert witness in economics and sociology with a particular interest in housing discrimination.
Yes, Your Honor. Dr. Kennedy has expressed only an interest in this field, and we have not heard anything that convinces us of her expertise in the very limited area of housing, and her degrees are actually in economics and sociology.
She has her doctorate degrees in economics and sociology. I believe that qualifies her as an expert in those fields.
Will it admit your objections will go to the weight that will be given to her testimony?
Have you ever done any studies on adults-only communities, Dr. Kennedy?
Yes, I have. In 1984, I examined housing discrimination in Philadelphia, and in 1980, I supervised a study done by the U.S. Department of Housing and Urban Development.
In your study, did you look at society hotels?
Yes, I did.
What conclusion have you come to about the adults-only complexes?
Through my examination of society hotels in my 1984 study, I found absolutely no economic advantages. I didn't see any insurance values decreasing or property values increasing, and I saw absolutely no decrease in the maintenance value when children were restricted from living.
Could you please mark your claim to Exhibit 1?
Objection, Your Honor. The council requests to see this exhibit.
Could you please identify...
You need a map?
Yes. Could you please identify this document in court?
This is Society Hill's operating expenses in years 1975 and 1984, as compiled by my survey in 1985, Housing Discrimination in Philadelphia.
Your Honor, the plaintiff would like to admit this as Plaintiff Exhibit 1.
No, Your Honor.
Could you please tell the court about the increases in expenditures shown on the chart?
Overall, Society Hill Towers have increased their expenditures $120,000 from their conversion of apartments to condominiums, and this is with the adults-only restriction. This is a 3 times increase.
Let's look at each category. Tell us about the increases in expenditures on administration.
administration, there's been a very significant increase. It has increased $40,200, a percentage increase of 709.1%.
What about maintenance?
Maintenance has also increased by $33,000, or 339.1%.
What about insurance expenditures?
Again, the insurance has increased by $19,800, or 184.6%.
What about the recreational staff?
This has been the most significant increase overall. The recreational staff has increased by 900% after the adults-only restriction was admitted to Society Hotels. This is a $19,200 increase.
What about repairs, Dr. Kennedy?
There's been a 150% increase in repairs, a $6,600 increase.
And what about miscellaneous expenditures?
Even the miscellaneous expenditures of Society Hotels have increased, and that has been by 300%.
Dr. Kennedy, why did you use 1975 and 1984 as the dates for your study?
In 1975, this was prior to D&G's conversion of Society Hotels apartments to condominiums. Therefore, there was no adults-only restriction. In 1984, the D&G developers had already converted it to condominiums, and they have enforced their adults-only restriction. According to D&G developers, the increases should not have occurred, and they have.
In your expert opinion, what does this study show about adults-only communities?
This study very clearly points out that there are no economic advantages to the adults-only living conditions.
Do your studies address the vacancy rate of houses and apartments?
Yes, the study I supervised in 1980, it did address the vacancy rate in Philadelphia.
What is the current vacancy rate in Philadelphia?
It's less than 1%.
How many of these are children?
Full 25% do.
And how many restrict the ages of children?
Over 50%.
How many have any type of child restrictions at all?
76%.
Based on your studies, do you see any reasonable relationship between the adults-only provision and the protection of the health, safety, economic, and general welfare of the people in Society Hotels?
I see absolutely none. As I pointed out from my study, there are no economic advantages, and as a sociology expert, I really don't see how discriminating against an entire class of people is beneficial to anyone, especially not the residents of Society Hotels.
Objection, Your Honor. Dr. Kennedy is testifying as a lawyer, as a judge, well-versed in the field of law. She's an expert not in the field of law.
She is an expert in the field of economic and sociology. Do you know the Pescos, Dr. Kennedy?
Yes, I am.
The Pescos?
Yes, I am acquainted with them.
How do you know the Pescos?
Andy was a very fine student of mine before his tragic death at Penn State.
Is the fact that you know the Pescos influencing your testimony in any way, Dr. Kennedy?
No, it is not. I conducted my studies and did my conclusions, and it was done prior to Angie's death and prior to anything even happening with Society Hotels. All my studies were done before anything happened with the Pescos, and therefore the information cannot be biased by my relationship with the Pescos.
Thank you, Your Honor. No further questions. Dr. Kennedy, is your study, Plaintiff's Exhibit 1, a complete study?
Yes, it is. It's a complete study of Society Hotels operating expenses.
But I believe nowhere on here do I see exactly what constitutes administrative costs.
Well, this is done from my background because I have studied.
Do you state anywhere on here just exactly what goes into the administration costs?
No, I do not. I did not feel it was necessary.
Your Honor, we object. Counsel's badgering the witness. We would ask that you let her finish her answers, please.
Dr. Kennedy, referring to the Plaintiff's Exhibit 1, which you have identified for the court, that study doesn't take into account the effect of inflation in the past 12 years, does it?
No, there was no reason to because this is Society Hotels operating expenses, not inflation growth.
And Dr. Kennedy, from whom did you find out about this trial?
I heard of it from Miss Pesco's. Andy Pesco's mother.
You did know the Pescos, did you not?
Yes, I have testified that I am acquainted with them. Andy was a student of mine at Penn State.
And wasn't Mr. Pesco Joseph's son-in-law?
Yes, I believe he was.
And isn't it true that after their son-in-law died, you were asked to look after his widow? Were you not?
As a friend of the family, they asked me to do everything I could, as I'm sure the other friends of the than we have done. But as
And
I
isn't it
said,
true that Mr. Pesco's widow is the Joseph's daughter, Fran?
yes, she is.
Dr. Kennedy, since you suggested that you are an expert in the field of economics,
I have been told.
and you have encountered some studies done by other experts, I'm sure you're aware of certain studies done in the field of economics by Ms. Janet Hook.
Yes, I am acquainted with those.
And I'm sure you're aware, aren't you, that Ms. Hook's studies show that as a result of Society Hill Towers becoming an adults-only, their expenses have decreased dramatically?
I know Ms. Hook is an expert in her field. However, I do not have specific knowledge of Ms. Hook's studies or any one specific study.
Yeah, may I approach the witness, please? Ms. Hook, these are the affidavit of Dr. Kennedy. I'll identify the patient for you.
Thank you.
On page 3 of your affidavit, which you prepared for this trial, could you please read this line right here? Referring to page 3 of Dr. Kennedy's affidavit.
I have read Jonathan Hook's treatises and analyzed them carefully.
Thank you. Dr. Kennedy, isn't it true that you first met Ms. Hook when she was a student of yours?
Yes, she was a student of mine.
And wouldn't you agree that the student-teacher relationship you had with Ms. Hook wasn't a positive?
Your Honor, we object. This is irrelevant to the case. Society Hill Towers is nursing Arnold Joseph. It's not Dr. Kennedy and Miss Hook's relationship in the classroom.
Your Honor, the plaintiff did present Dr. Kennedy as an expert, and I'm just simply challenging her expertise and the credibility of the witness.
What does that have?
Proper cross-examination. And isn't it also true that you based Ms. Hook's grade on the fact that you felt she was morally insensitive?
Your Honor, once again, we object to this. It's irrelevant once again. What her grade was in college has nothing to do with this trial here today. What Dr. Kennedy gave Ms. Hook a grade some 20 years ago has nothing at all to do with what goes on here today in this court. We're Society Hill Towers versus Annette Joseph.
Yes, Your Honor, I'm trying to show the credibility of the witness and my may be biased through my line of questioning. But she is familiar with both parties of the trial of this case. And Dr. Kennedy, one last question. Did a student of yours have to be a morally sensitive person in order to pass your economic courses?
Your Honor, once again, we object. This is irrelevant.
Nothing further, Your Honor.
Your Honor, the plaintiff requests the
Your Honor, I'd like to call Ms. Juanita Price to the stand.
Thank you very much.
Could you please state your name and address for the court?
My name is Juanita Price, and I live at 4501 in Unit 1A of Society Hill Towers.
What's your position with the Society Hill Towers?
I'm president of the Homeowners Association.
Ms. Price, when did you take on this position?
In 1980, after the death of my father.
Do the building representatives meet regularly?
Yes, they meet quarterly.
Did they meet on October 15, 1984?
Yes, they did.
What specific decisions were made at that meeting?
It was brought to my attention that the Josephs were in violation of the rules of the Homeowners Association.
What rules were violated?
Well, as you know, we're an adults-only condominium complex, and when the Josephs allowed their daughter and their grandson to come back to live with them, they broke the rules.
How long have these rules been in effect?
Ever since the conversion of the apartment complex into condominiums.
Did the association provide any exception to the new rules?
Yes, we did. The exception was that anyone living at Society Hill Towers before January the 1st, 1977, and was under 21 years of age were permitted to stay.
Ms. Price,
Price, did this exception apply to all the children living in Society Hill Towers
Yes,
at the time of the conversion?
very exclusive offer, yes.
Does it apply to anyone who was not living in Society Hill at the time of the conversion?
No, it was a very exclusive offer.
Ms. Price, going back to the October 15th meeting, did any of those decisions made involve the Josephs?
Yes.
Was a vote taken?
Yes, it was. The vote was 9-7, and at the meeting, we had a majority. The decision was that we decided, I came up with the idea of giving the Josephs a 3-month grace period to remedy their situation.
And Ms. Price, did that vote constitute a majority of the representatives present at that meeting?
Yes, it did. There were 16 people at the meeting. There's a 20 building representatives. 16 was a majority at the meeting.
Did you notify the Josephs of their violation?
Yes, we did. They were hand-delivered a notice by their building representative 2 days after the meeting.
What was their response?
They were in disbelief. I have a job to do, and I feel for the Josephs, but rules are rules. I had to verify the authenticity of the paper and the notice.
Ms. Price, why is there a restriction on children?
They are very destructive.
Would you please state any examples?
We have this girl at the Society Hill Towers that like to set things on fire. She set numerous things on fire. She set an elderly woman's condominium door on fire. They like to have all-night pool parties with drugs and alcohol. They're very destructive. We have to pay for what they mess up.
Ms. Price, what were the primary reasons for the adult-only conversion?
Economic reasons.
And Ms. Price, once the rules and regulations and the deed were presented to the residents, did you receive any questions from them about the conversion?
Yes, we did. You know, people were worried about their children or whether or not they had to move because they had them. And as to my knowledge, all the questions were answered satisfactorily.
Were there any complaints from the residents prior to the suit after the conversion?
You know, this is the very first one.
Second letter, Your Honor.
Affidavit, Ms. Price, you stated that it would cost too much money to put in facilities to accommodate children, did you not?
Yes, I did.
And yet isn't it true that Society Hills has added an Olympic-sized pool since the conversion, a new Olympic-sized pool, Ms. Price?
Well, we've been in effect from 77 until 1986. I'm trying to answer your question. The pool is not what you might call new because from
Did you add an Olympic-sized pool?
Yes, we did, but it's not new.
Did you add a new fitness center, Ms. Price?
That's not new either, but yes, we added it.
Were you present at the October 15th Homeowners Association meeting?
I'm president, yes, I was.
And was it at this meeting that action was taken against the Josephs?
Yes.
Are you aware that Francis and Edward have been living with the Josephs since January 5th of 1985?
Yes, I am aware.
Yet, isn't it true that no action was taken against the Josephs on the January 15th meeting?
Out of pity to let them live there that long. Enough is enough.
Nor on the April 15th meeting?
Enough is
nor on the July 15th.
Enough is enough. We finally decided after 10 months, and she had not found a place to live, that we should use the power that we have as the Homeowners Association.
You answered my question.
Yes,
so you waited 3 quarterly meetings before taking action?
Out of pity, yes.
Isn't it also true, Ms. Price, that you waited 9 officers' meetings passed without any action taken against the Josephs also?
Pity.
Did you wait? Would you please answer my question?
I'm trying to answer your question.
But you're rambling on.
I'm trying to answer your question.
We'll move on to another question.
Okay, thank you.
Concerning the deed, Mr. Price, isn't it true that there is no specific penalty to deal with those who are in violation of the adults-only provision?
No, but as president of the Homeowners Association, I think I'm very justified in constituting the penalty.
So you make the penalty up yourself, Ms. Price?
They voted on it.
So then the association is acting arbitrarily since they have nothing to guide them on, correct?
No, I'm sorry, but as DMG developers have said in the stipulated facts that they need the power to come up with...
the word eviction mentioned, correct? I'm sorry, Your Honor.
To come up with, how should I say, the penalties is up to the association. How can we say that? I mean, she's been here for 10 months. How were we supposed to foresee this?
Nowhere is the word eviction mentioned in this deed at all.
No.
Doesn't the deed specify that those persons residing in Society Hill Towers as of January 1, 1977 were exempt from the adults-only provision?
Edward was not living there at that time.
Was Frances living there, Miss Hope?
Yes, she was, and she is an exception. She herself, not Edward, her.
So you would have the Josephs throw out just Edward, not Frances?
No, let Frances go back, get her GED, get a job, and move out. I feel for them, but...
Thank you, Ms. Price. You answered my question. Isn't it conceivable that there are persons living in Society Hill Towers with children as young as 9 years old who are living there as of January 1, 1977?
I didn't hear the first part of the
Isn't it conceivable that there are persons with children as young as 9 years old living in Society Hill Towers?
Yes, again, there are exceptions, yes.
So
there are children living there.
And it's your contention that children cause damage to property?
Objection, Your Honor.
She stated it in her direct examination, and it's also in her affidavit.
Children that might be living in the condominium that could be 9 years old is not found anywhere in this case, and it's also irrelevant.
Mr. Price, could you tell the court how long a person must be living in Society Hills to constitute residency?
I don't understand that question.
How long must a person be living in Society Hill Towers before they are considered a resident, Mr. Price?
I don't know how do you want me to answer that question? Do you want me to say 2 months, 3 months? I don't understand
Is there anywhere specified in the deed or in the bylaws of Society Hill Towers Homeowner Association which specify how long a person is considered to be a resident that's living?
Well, if you live in some place for 10 months, I consider them
You consider them a resident yourself?
Well, you're asking me, aren't
Yes,
you? Me, not as president. Are you asking?
Mr. Price, didn't you say rules are rules, we must all live by them?
Yes, I did.
And this is the same reason you gave to Josephs for taking this action against them, correct?
I didn't hear the
This is the same reason you gave to Josephs for taking this action against them, isn't it?
I don't understand that question.
You said rules are rules, we must all live by them. And you gave, when the Josephs contacted you, you said this to them, correct?
No, I didn't. I explained to them the meeting, what happened in the meeting.
Mr. Price, would you please read? Yes, ma'am. Mr. Price, will you identify this as your affidavit, please?
Yes, it is my affidavit.
Will you please read this paragraph from there, page 1 of Juanita Price's affidavit from the until them.
Okay. Until where?
Mr. Price, would you please read?
Okay. The Josephs were in violation of their deed, and either they or their daughter and her son had to go. I care about the Josephs, but had to support Lauren. Rules are rules, and we all have to live by them. But that doesn't mean I said that to him during the conversation on the telephone.
You stated yourself that you decided to give the Josephs 90 days to a 90-day grace period, as you called it.
3-month grace period, yes.
And you decided this yourself without consultation of the Homeowners Association?
Well, we were at the meeting. I came up with that suggestion. It says there, I suggested. We voted. They agreed upon it. So obviously they didn't have any gripe with it.
Did you state in your direct examination about a girl who set doors on fire, Ms. Price?
Yes, I did.
I'd like to refer to witness's affidavit once again. Counsel, I'm going to use Price page 2, third paragraph.
Objection, Your Honor. Counsel did not ask if he may be able to approach the witness.
No, I approach the witness. Would you please identify this once again as your affidavit?
Well, yes.
Thank you, Ms. Price. And would you please read right here from we until...
We had one kid here back here in 75 who thought it was fun to burn things up. Trash can, trees, even buildings. She set them all on fire.
Thank you, Ms. Price. Is the word...
If you read further, it says she set an old woman's door on fire.
Does it say anywhere that's the same girl, Ms. Price?
Read further.
Does it say anywhere that is the same girl, Ms. Price?
If you read further, it'll say.
Ms. Price, it does not say anywhere.
Not from where I read, that's just one small specific part
No
from
further
my
questions, Your Honor.
affidavit.
May it please the court, I'd like to call Ms. Janet Hook to the stand. Please state your name and address.
My name is Joan Hook, and I live at 220 Lincoln Drive in Philadelphia.
Will you please describe your schooling and qualifications?
At Pennsylvania State University, I received my BA in economics, and at Temple University, I received my master's of business administration.
What is your occupation?
I am the owner and chief executive officer of Corporation.
Could you please describe some of the articles that you have had published?
I have published articles on management strategies for homeowners associations, particularly on the advantages financially and management-wise of the adult-friendly complexes.
Your Honor, the defendants would like to offer Ms. Hook as an expert in the field of management and financial strategies for homeowners associations.
No objections, Your Honor.
Ms. Hook, have you written any studies pertaining to Society Hill Towers?
Yes, I have written studies on Society Hill Towers.
Your Honor, we ask the bailiff to mark these exhibits D1 and D2.
Which is my pleasure.
Your Honor.
Thank you.
Thank you.
Your Honor, may I approach the witness? Ms. Hook, I am handing you two documents, one marked D1 and one marked D2. Could you please review them and tell us if you recognize them?
Yes, I do recognize them.
Do they consider Society Hill Towers?
Yes, they are specifically about Society Hill Towers. D1 is the projected property value of Society Hill Towers, and D2 is the Society Hill operating expenses from 1975 and 1984.
Please consider Exhibit D1. What does it show?
It shows that the projected property values of Society Hill Towers are higher with the adults-only provision and lower with the children there.
What conclusions do you draw from this chart?
That Society Hill Towers as an adults-only community is worth more.
Please consider Exhibit D2. What does it show?
This shows Society Hill operating expenses from 1975 and 1984, and that insurance and repairs, the ones that relate more to the children, are, in fact, have fallen.
Exhibit D2 seems to indicate that some costs have increased. Why?
Well, maintenance has increased almost 3%, and nothing stays the same in 10 years.
In your expert opinion, what conclusions can you draw regarding overall property expenses for Society Hill Towers?
That without the children there, without the children there, it is more economic and better.
Would the fact that Society Hill Towers is an adults-only complex cause expenses to go up?
No.
Based on your experience, if the Josephs were to sell their condominium, what type of profit would they enjoy?
A very lucrative profit. I just sold 12 units of Society Hill Towers for an average price of $75,000.
How difficult would it be for Francis and Edward Pesco to find housing in the Philadelphia area?
At any random time, there's approximately 100 apartments, single-bedroom apartments open, and every day I have landlords coming to me wanting me to fill their apartments.
Thank you, Ms. Hook. Counselor, your witness. Hook, isn't it true that you said you are receiving no money for testifying in court today?
Yes.
And isn't it true that you are normally paid for your testimony?
Yes.
Isn't it true that you receive a commission for sales of units for Society Hill Towers Complex?
That's part of my job. You usually do get paid for doing the job.
So you do receive money through Hook Realtors for selling units for Society Hill Towers?
I am the owner and chief executive officer of Hook Realtors.
Your Honor, I'd like to refer to Defense Exhibit 1. Ms. Hook, this value you have obtained for 1985, it is a projection and not an actual value, is it not?
It's a projection, but as I stated before, that I just sold 12 for an average price of $75,000, and that's over my projection.
Ms. Hook, when were these values prepared?
In 1976.
And this projection was made 9 years prior to 1985 then, correct?
Yes.
So therefore you were predicting what was to happen in a period of 9 years.
That is part of my job.
So therefore, your predictions were made 9 years ago, and they do not include the adult-only restriction being applied to Society Hill Towers in 1977, correct?
I've already stated that my projections are lower than what the actual price is today.
But the adult-only restriction did not apply when you made your studies.
Yes.
So now that Society Hill Towers is an adult-only complex, do you feel that you can sell a condominium for your projected value and actual value you have sold them for $75,000?
Even I don't understand the question.
So now that Society Hill Towers is an adults-only complex, do you feel that you could sell a condominium for your projection value of $75,000 today?
Yes, I have stated I sold 12 condominium units at Society Hill Towers for an average price of $75,000.
So this would include the Joseph's condominium, would it not, for it is in Society Hill Towers?
Yes.
So even though Miss Pesco and Edward are living there with Miss Joseph, you could probably sell their condominium for the value of $75,000.
Yes, I have stated several times that I sold 12 for an average price of $75,000.
Your Honor, I'd like to refer to Defense Exhibit number 2. Isn't it true that maintenance costs have increased, Ms. Hook?
Only 3%.
But they have increased.
Yes.
And isn't it also true that administration has doubled?
As I stated before, the cost of anything increases in 10 years.
But they have doubled, have they not?
Yes.
And recreational staff has tripled, has it not?
Yes. But the price of anything, or the cost of anything goes up.
It has tripled then.
Yes.
Isn't it true that in 1975, Society Hill Towers was an apartment complex?
Yes.
And in 1984, Society Hill Towers is now privately owned property by each individual condominium owner.
Yes.
Isn't it true that a person takes care of a place if they own it themselves more than if they would just rent it?
Yes.
So the condition of the condominium is not affected by Edward and Miss Pesco residing there at Society Hill Towers.
Excuse me?
So the condition of the condominium is not affected by Edward and Miss Pesco residing there with the Josephs.
I have no idea what Miss Pesco and her son do in that condominium. I wouldn't know how that affects me.
I have no further questions.
No further questions, Your Honor. Defendant's rest.
Yes, Your Honor.
Your Honor, ladies and gentlemen of the jury, thank you for coming here and giving your time and attention to both sides before organizing your own theory of this case. In 1977, Society Hill Towers apartments were converted into condominiums. All current residents were given the opportunity to purchase their homes, providing that they agreed to the new restrictions found in their deeds. Each deed contained a special restriction concerning adults only. Many current residents had small children, so as a consideration for them, the special exception was also included in each deed. All those under 21 years of age living at Society Hill Towers as of January 1st, 1977 were allowed to remain. The judges indicated their approval of this restriction along with the rest of the homeowners by signing their deed. The Josephs, we maintain that while our sympathies are with the Josephs, the time of protesting was 9 years ago. The Josephs are here today protesting against a restriction that they approved of in 1977. The Josephs are in violation of their deed, and they are aware of this violation. Unfortunately, the Josephs seem to feel that rules should only be followed as long as they want to follow them. Ms. Price has indicated to the court that no other resident feels that this discrimination is arbitrary, and all the other residents still support the restriction. The testimony of Ms. Price proves that costs declined when the community became adults only. Ms. Hook has no financial interest in the outcome of this case. Her only interest is purely humanistic. But where did Dr. Kennedy's interest lie? She herself has admitted more than a passing knowledge of both plaintiff and defendant. Therefore, she is here today with a personal interest, not an unbiased opinion. The testimony of Mrs. Joseph speaks for itself. She apparently never felt it was her duty to understand the deed, or else she wouldn't have signed it. Now, they are here today asking for special privileges that no one else in the community is seeking. We ask the court to reaffirm the power and the authority of the Homeowners Association to enforce this provision against the plaintiff. We ask the court to grant our counterclaim for repossession of Unit 3A of Building 4519. Many rules and facts and costs and charts were brought to your attention this evening. Charts and costs are not the real issue. The real issue is rules. Rules are never made to harm or injure. They are made only to benefit or protect. For the past 9 years, the Joseph family has enjoyed all the benefits provided to them by the association. They were aware of the restriction in their deed before they signed it. And they were aware that although Francis was allowed to stay, that did not open the door for any future generations to move in. We do sympathize with the Josephs and will try and help them, but the principle of laws and rules must be upheld. The evidence has proven that our client's adults-only community is not arbitrary discrimination. In 1976, the Philadelphia Court of Common Pleas established a three-pronged test to prove when discrimination is in fact arbitrary. First of all, discrimination is not arbitrary if it is reasonably related to protecting health, safety, economic, or general welfare. The general welfare of the other tenants of the community does not seem to be taken into consideration at all. Ms. Price has indicated to the court all the troubles and inconveniences the tenants experienced when children were living at the complex. They are certainly not alleging that Edward will grow into anything other than a model teenager. We cannot guarantee this. Secondly, discrimination is not arbitrary. It does not cause unreasonable harm to the person affected by the act of discrimination. Ms. Hook's testimony proves that if the Josephs would sell their condominium, they would stand to a large profit. Lastly, the distinction is not arbitrary. It does not cause unreasonable harm to the public interest. The public this case concerns includes only those tenants of Society Hill, and their interests do not seem to be taken into consideration at all. Again, our sympathies are with the Josephs, but rules are never intended to harm. We are sure the evidence has proven that the association's laws are intending help, not harm. Again, we are asking the court to reaffirm the power and the authority of the Homeowners Association. We do agree with the plaintiff in that arbitrary discrimination is wrong, but adults-only communities do not fall into this category. Adults-only communities are economically beneficial and therefore not arbitrary discrimination. The United States of America was heroically founded on the time-honored concept of providing and protecting for the early citizens. As the years passed, our country thrived on the finest regard for laws and rules. Rules are never made to harm or injure. They are made only to benefit or protect. Age requirement laws have only ever been established to help. Our public educational systems have established an age requirement. This certainly wasn't established to harm, and it definitely isn't arbitrary. The driving age and the drinking age were definitely established to help. Age requirement laws are an obvious fact of life. They are established only to help and protect as much of the general public as possible. Do not let this country bow to those who feel rules should only be followed as long as they want to follow them. Your Honor, ladies and gentlemen of the jury, thank you.
Your Honor, may it please the court. Ladies and gentlemen of the jury, opposing counsel. No person under the age of 21 years shall be permitted to reside in Society Hill Towers. This is the adults-only provision found in everyone's deed at Society Hill Towers. Ladies and gentlemen, it is the plaintiff's contention that the defendant's proposed action against the plaintiff is a flagrant example of arbitrary discrimination, which is prohibited and is in violation of the Philadelphia Civil Rights Code. It is further the plaintiff's contention that Society Hill's action is arbitrary discrimination, for it does not pass the three-pronged test set down as Farnback versus Anderson, 1976. It is important to note that for discrimination to be considered, not to be considered arbitrary, it must pass all three prongs of the three-pronged test. Today we will show that it not only fails one, but it fails all three, and doing so is definitely arbitrary discrimination. First, let's examine the fact that the adults-only provision is not reasonably related to the protection of the health, safety, economic, or general welfare of the community. Let's first examine the health and safety aspect. Mrs. Joseph testified that her car was stolen and her other car stolen she knew of. Ms. Price, the president of the Homeowner Association, who I think agree was a hostile witness, would be in a position to testify that in fact crime has gone down or crime has gone up. They introduced no studies whatsoever that would indicate that crime has gone down since the conversion. They only used Ms. Price's testimony, which has been brought to considerable doubt as the credibility of it. Therefore, we can see that the fact of the matter is that the health and safety of the residents of this community now and today may be no greater than it was prior to the conversion. There is no real evidence. We, however, give evidence that cars were indeed stolen since the conversion. Now for the economic and general aspects. In the testimony of Dr. Kennedy, we have all seen the costs have gone up, that the conversion has not saved the homeowners money. We have seen that administrative costs have risen 709% since the conversion. The recreational costs have risen 900%. 900% since the conversion. Insurance costs have gone up 185%, and maintenance costs also have risen 339% since the conversion. This indicates that costs have indeed risen, costs which the homeowners pay. In addition, Dr. Kennedy's information, if you'd like to know, is far more accurate than Ms. Hook's, who made Nostradamus-like predictions back in the late 70s. Ms. Hook's information was all compiled in 1975, and the present values are only projections, whereas Dr. Kennedy did actual research prior to and after the conversion. Ladies and gentlemen of the jury, there are no economic advantages when you are paying more for something now than you were 9 years ago. Therefore, the provision fails the first prong. Secondly, the provision causes unreasonable hardship for the persons affected by this act of discrimination, the Josephs. 10 months passed before the Homeowners Association chose to take any action at all. This was cruel and unusual. While the Josephs did not want Fran to live with them forever, they were under the impression they would have time to find Frances a place to stay that would be suitable for raising her infant son. They were under that logical inference, so the Homeowners Association waited 10 months to take action. Then out of the blue, the Josephs get a note. This is an unreasonable hardship. It is important to note that there is no penalty stated to deal with those who violate the adults-only provision. The Homeowners Association has nothing to guide them. They have acted whimsically and arbitrarily in their dealings with our clients. The Josephs did not know the penalty would be eviction. It's not stated anywhere in the deed or the bylaws. The arbitrary action the homeowners have taken causes unreasonable harm to the Josephs. The Josephs' understanding of the deed was that, as D&G's attorneys explained to them, the persons living in Society Hill Towers as of January 1, 1977 would be exempt. Those persons include the Josephs and Frances. The defense brings up an interesting point that Edward wasn't living there, and therefore he shouldn't be allowed to live there. They have no qualms about Frances living there. They'd like us to kick out their infant son, Edward. Very interesting. Frances had no background to get a job. She has no income. She can't very well afford housing at this time. That's, again, a fringe of practicality here. With this in mind, the Homeowners Association action is both cruel and unusual. An important question raised in today's trial is what period of time constitutes residency. Ms. Price, the president of the Homeowners Association, could not answer this question. The same Ms. Price, who gave the Josephs the reason for eviction that, well, rules are rules, we must all live by them, breaks these rules by allowing her niece and nephew to visit her once a week and a month, and would like to allow them to visit more often. Since there are no requirements for residency, we can consider this residency. see that she's in violation of the rules, that she says rules are all rules. Therefore, it fails the second prong, causes unreasonable hardship. Thirdly, the provision causes unreasonable harm to the public interest. Dr. Kennedy has testified as an expert that the adults-only provision has set a dangerous trend in the housing industry. That the rise of adults-only communities is detrimental to the well-being of Philadelphia, of Pennsylvania, and the United States of America. It erodes the family unit, as we have seen in this case. The Josephs are being forced to either surrender a home which they have fond memories of, which they put many years into building, or kick out their granddaughter, or grandson, and her daughter. This trend has been set, which results only in a 1% vacancy rate in the Philadelphia area. And of this, 76% of housing is anti-child restrictions. 76%. 50% restricts the number of children and the age allowed to live there, and a full 25% bar children completely. With these kind of odds, these types of statistics, what chance do the Josephs have of finding housing? They bring up with the family as a crime, and this brings it on. Therefore, it fails the third prong and is arbitrary discrimination. Let's examine the defendant's case for a moment. They claim that Mrs. Joseph knew it was in the deed. Well, she did know, but she didn't know what applied to it was explained by the attorneys. They stated this is important to their client, this case. But what about our client? What about Mrs. Annette Joseph? It's not important to her that she may have to kick out her family and lose her home because she didn't understand the deed or because society feels it's acting with arbitrary discrimination. Keeping all this in mind, the plaintiff is asking the court to do three things. Number one, to declare the adults-only provision is violated with the Philadelphia Civil Rights Code as a form of arbitrary discrimination. Number two, to declare the restrictive provision is null and void. Number three, to enjoin the Society Hill Towers Homeowners Association from taking any action to enforce this adult-only provision against our client. Ladies and gentlemen of the jury, and your honor, I'd like to thank you, and we are confident you will render a just verdict.
I believe at this time to take a 15-minute break so that the scores can tally up.
All rise. Court is now in recess. Springfield following.
I should indicate, first of all, that age restrictions in housing has withstood constitutional attacks. And since age is not a suspect classification, the proper test for determining whether an age restriction denies due process or equal protection is whether the restriction under the particular circumstances of the case is reasonable and whether it is discriminatory, arbitrary, or oppressive in its application. Now, under the law and the facts as set forth in this trial, the court does hereby enter judgment in favor of the defendants. Before you receive your score points, I would like to commend all of you on the fine performance. I believe that some of the attorneys that I have seen in my courtroom recently could learn something from you, and I am very sincere in that. Just a few comments. I will make just a very few comments. You will receive the score, and then the panelists will be available to discuss with you anything that you may wish to have criticized or praised, what have you, but they will be available. Some of you, I think, are going to have to slow down. You're talking too fast. If there would have been a court reporter here, the court reporter would have had some difficulty with at least two of you. So keep that in mind. Some of you have the habit that I have seen even the professionals use, and that's to begin a question with the word and, repeatedly, and try to avoid that. Cutting off witnesses or witnesses and the questioner talking at the same time also becomes a problem. Now, I know that you were not permitted redirect or recross, and many times that particular problem can be cured by counsel on redirect or recross, enabling the witness to explain a brief answer given on cross-examination. Sometimes it's not wise to cut off an individual. Sometimes you get more information from them by letting them ramble on, although there comes a point where a witness obviously has to be stopped. But sometimes the most dangerous witness, that is dangerous to the person who called the witness, is the rambling witness. And it may be beneficial to the other side sometimes to let them ramble. You may be able to get more information that will be helpful to you. Try to avoid notes. Now, I don't mean entirely, but don't read them. Have them available, refer to them, but you lose your contact with your jury by reading from your notes. And you can certainly use notes in cross-examination or direct examination.